Okay. All right. So thank you everyone for joining me today for today's presentation about caregiver resources, legal solutions for caregiving barriers. My name is Rachel Funk. I'm the supervising attorney of the Legal Advocacy for Older Persons Project at Southern Minnesota Regional Legal Services. And November is Caregiver Month in the United States. And so we wanted to give a presentation this month that goes through some of the legal options and legal solutions for common caregiving barriers that we see in our work. So I'm going to start with talking a little bit about Southern Minnesota Regional Legal Services, or SMERLS as we call it. SMERLS was founded in 1909, and we provide free civil legal help for people in need in the 33 counties of Southern Minnesota, and that includes counties as far north as the metro, like Ramsey. Legal aid programs generally take cases for clients when those cases don't generate attorney's fees or the types of cases that private attorneys won't take for another reason. More specifically, our project, the Legal Advocacy for Older Persons Project, provides free legal help on critical legal issues that affect folks age 60 and over in the greatest social and economic need in our service area of those 33 counties. Our project is funded in part under the Federal Older Americans Act through the local area agencies on aging. And as part of that funding, we do not and are not allowed to do what's called means testing to determine eligibility for our services for that population. And what that means is, while we might ask you for income and asset information, because it might be relevant to the legal issue you're contacting us about, we do not use income and assets to determine if we can assist you. So we do not have an income limit or income minimum or an asset limit or asset minimum that we use to decide if we can provide our free legal assistance. I do want to just highlight here, since I'm talking today about resources for caregivers and for people who receive services and assistance from caregivers. Our office provides legal services to the older adult. So sometimes we may have a caregiver contact us about a person that they are taking care of. And for us to be able to look into the matter and see if we can provide assistance, we do need to have either contact with that older adult themselves to make sure they know that we're working on it and that they want us to, or have the caregiver provide us with proof of a legal right to contact us on that person's behalf, such as a power of attorney or guardianship. SMERLS, generally speaking, has a number of different practice areas. So we provide legal services in the areas of housing, which includes landlord-tenant issues and also can include things like condemnations. We also have a unit that handles economic justice matters, including public benefits and some disqualifications for licensing, things like that. We have a family law unit that focuses on remedying and addressing issues related to domestic violence for clients. We have an education law project that practices to provide legal services to minors and others who are in the public education system. We have a consumer law unit. They work on a variety of different debt-related types of issues. We have an immigration law unit that handles certain cases related to immigration. We have our project, the Legal Advocacy for Older Persons Project, and we also have an agricultural workers project that works on behalf of agricultural workers in Minnesota and parts of South Dakota. We also at SMERLS have a hotline that is staffed by experienced attorneys who can provide legal advice over the phone on a short-term basis, and intake callers are frequently able to talk to the hotline on the same day that they complete their intake. For the Legal Advocacy for Older Persons Project, we address a number of different issues in our work. clients contact us about a lot of different things, and we try to assist wherever we can. So that includes things like eviction from independent housing, can also include nursing home discharges, assisted living contract terminations for services and or housing, termination or reduction of care services. So that might be a reduction in the number of care hours you've been provided by through a MinChoices assessment. We also handle cases related to appeals of public benefit denials, reductions, or terminations. So that could include things like a SNAP termination. It could include a reduction in SSI benefits or a reduction or a termination of Social Security retirement benefits. We also handle cases related to elder abuse and exploitation, including trying to find a legal solution to remedy the exploitation or providing referrals for places that you can go to pursue a criminal case or something like that. We provide assistance frequently with fair housing, reasonable accommodations for clients so that they can have their disabilities accommodated in their home. And we also provide advice and referrals on other issues. We assess each case individually. As long as the person is eligible for our services, we look at their case individually at SMERLS to determine whether we can provide representation or advice and what that advice or representation should look like. There are a variety of ways to reach us to complete an intake to determine your eligibility for our services. Telephone is still typically the most efficient way for prospective new clients to connect with us. Our phone number is listed here. It's 1-877-696-6529 or 877-MY-MN-LAW. And those intake lines are staffed typically from 9 a.m. to 3 p.m. on weekdays, excluding holidays. That number is actually a statewide coordinated intake number for all of Minnesota. So most of the legal services providers in Minnesota participate in what's called a coordinated entry, which means that if you call this number, the 877-MY-MN-LAW, you give your zip code or location information and you get automatically routed to the legal services agency that provides services in your area. So you don't have to know specifically that SMERLS is the right legal services agency. You just contact this phone number and you get routed automatically to the right place. We also accept intakes through our website, and I put the URL here. It's https://smrls.org/how-we-can-help. So you can request to complete an intake through our website. You can start the process and then we contact you by phone to finish the process. And you can also visit in Minnesota lawhelpmn.org. That is a resource for folks with a lot of different fact sheets and information, and also contact information for how to reach out to different legal services organizations. So those are all good options for connecting with legal services when you have a legal issue. When you complete an intake, we do have to gather some information to make sure that you're eligible for our services. So that can include, or does include, your name, your date of birth, your telephone number if you have one, your address if you have one, and if you're using a safe at home address, of course, we would accept that. And then a basic description of the legal problem that you're contacting us about. You don't need to be the expert in your legal problem. Instead, it's just helpful for us to figure out who is the best person for you to talk to about the legal problem. If we have a sort of a general sense of what it is that you're facing, that just helps us kind of refer it to the right person within our organization. For language accessibility, SMERLS does employ personnel who speak a number of different languages, including English, Spanish, Somali, Hmong, and Vietnamese. We also employ other staff that speak other languages frequently spoken by our clients. If we do not have a staff person who is able to provide interpreting for the call, then we use the language line service. So we can have a phone interpreter whenever you call in. We prefer not to use family members or children or friends of the client for interpreting. That would only be as a last resort if absolutely necessary. Otherwise, our preference and practice is to use interpreting through a professional phone service, and that is provided at no cost to the client. That is not something that we charge our clients for. Okay, so that's the background information about how to reach out to SMIRLs and the work that we do. And now I'm going to move on to the part of the presentation about the caregiver resources and legal solutions to common caregiving barriers. So during this presentation, I'm going to give a little bit of background on caregiving in Minnesota from a recent report that has been done by the AARP, a National Alliance for Caregiving. I'm going to talk about some common barriers to caregiving that we see in our work here, and then some legal solutions to those common barriers. And then I also have some additional resources that I've included in the slides that you can reach out to. The presentation slide deck is being provided to all of the registrants, so you will receive a copy of the presentation slide deck. If you're watching this presentation on Zoom, you may need to pause the Zoom so that you can write down or take a screenshot of the resources when I get to that slide deck. And I will try to keep it up there for a good amount of time so you can take that screenshot. Okay. So the AARP and National Alliance for Caregiving completed a report about caregiving in the United States in 2025. As part of that report, they also had a state-by-state breakdown of the results. If I remember correctly, the report for Minnesota was based on 164 interviews with caregivers in the state of Minnesota. So the numbers are approximate, based on those interviews, but they're very instructive as well. So there's an estimated 931,000 family caregivers in the state of Minnesota in 2025. And approximately 42% of family caregivers care for a parent of theirs. Approximately 22% of caregivers are living in a household with income under $50,000 a year. 12% of caregivers in the state of Minnesota live with a disability themselves. Approximately 27% of family caregivers in Minnesota are age 65 or older. Approximately 64% of family caregivers are female. And approximately 12% of family caregivers receive training for the caregiving work that they do in the activities of daily living, instrumental activities of daily living, or behavioral management. Activities of daily living are things like assisting the person you're caring for with day-to-day tasks like moving from the bed to a chair or physically feeding themselves. Instrumental activities of daily living are assisting with sort of more management style tasks. So things like shopping for groceries or managing finances, things like that. And then behavioral management is assisting the person you're caring for with managing their own emotions and managing their own behaviors, and also, some ways to manage those behaviors more externally. So things that you can do as the caregiver that can assist the client in managing their behaviors, like de-escalation, things like that. I've put at the bottom of this slide deck a link to the report for the state-specific findings. So if you go to that website, you can look at the full report for the United States, and you can also select whichever state you'd like to see the snapshot from. Okay. So next, I'm going to talk about the common barriers to caregiving that we see in our work here. This is not a complete list of all the barriers to caregiving in Minnesota. These are just some of the ones that we see pretty regularly that I wanted to talk about legal solutions that might exist. I think a lot of times when we're faced with a barrier like one of these, we don't understand that there could be a legal solution to that problem. And that's why we wanted to give this background information so that caregivers know that there may be a legal solution to the problem that they're facing that they could explore. So the four common barriers to caregiving that we see in our work is our time. So not enough time to provide caregiving, or not enough time for the caregiver to do other things that they need to do. Financial constraints, either on the part of the caregiver or the person receiving the care. Access to the person. So we do sometimes see situations where the person who would be receiving the care from the caregiver wants the caregiver to have access to them, and there's some kind of barrier to that caregiver having access to that person. And then little or no guidance. So that could be little or no guidance in terms of training for how to best be a caregiver, or skills to develop for caregiving. Or it could be little or no guidance from the person who is receiving the care about what it is that they want the caregiver to provide for them and how they want the caregiver to provide that care for them. So that could be a kind of a couple different areas there. I'm going to talk about the legal solutions, or some of the legal solutions to these barriers, one at a time. So I'm going to start with the barrier of time. One of the things that the AARP report showed is that 74% of Minnesota family caregivers worked while they're caregiving, and approximately 60% worked 30 or more hours per week while they were caregiving, which the report classified as full-time work. So, working full-time and providing care for a relative who's older, and potentially also for younger relatives or family members, can really be difficult. So there are some programs, some laws in the United States and Minnesota that do allow employees to take some time off from their work so they can focus on caregiving for periods of time. So I'm going to talk about 3 of those here. One is the Minnesota Earned Sick and Safe Leave Act. The second is the Minnesota Paid Family Leave Act, which is a newer law this year. And then also I will talk about the United States Family and Medical Leave Act, also known as FMLA, which you may be a little bit familiar with already. Okay, so Minnesota Earned Sick and Safe Leave is an employer-provided paid leave time at the employee's regular wage. So there's a law that requires employers to provide this type of leave to qualifying employees. And what the law says is the paid leave is at your regular wage, not including commissions or tips. So it's just the hourly wage. And that leave time, that paid leave, can be used for the employee to care for themselves or to care for a family member who is sick, injured, or has a mental health concern. And I put family member in bold here because I wanted to be sure that I talked about what does family member mean, because the statute says specifically what a family member means. And I think it's a very broad definition, and it's really useful to know who it is that you would be able to care for using this paid leave. So under the law, family member includes children, which can include your foster child, adult child, legal ward, someone that the employee is a legal guardian for, or a child to whom the employee has stood in the place of a parent. So a child that you have cared for as though you were their parent, even if you didn't have a formal guardianship or formal relationship there. Family member can also include the employee's sibling or step sibling or foster sibling, or any kind of a parent as well, including a step parent or a person who stood in the shoes of a parent for the employee themselves. So even if there wasn't that more formal relationship, this leave can be used to care for someone who acted as a parent to the employee. It's also available to use to care for an employee's grandchild, foster grandchild, or step grandchild, an employee's grandparent or step grandparent, a niece, nephew, or another child of a sibling of the employee, a sibling of the parents of the employee, so, aunts, uncles, or a child-in-law or sibling-in-law of anyone above, basically. And also those same types of family members for or individuals for the employee's spouse or registered domestic partner. And the statute also includes a really even broader category for individuals that are either related by blood or whose close association with the employee is the equivalent of a family relationship. So again, you could have a blood relationship with the person that you'd like to use this leave time to care for, but you don't have to be. If you have a close relationship that is like a family relationship, that is someone that you'd be able to use this leave to care for. You're able to designate up to one individual each year that you use this leave to care for. So you're not able to use it to care for multiple different people, but you can use it to care for up to one person besides yourself in a calendar year or annually. The way that the leave accrues is that you earn, as the employee, you earn up to 1 hour for every 30 hours worked, up to a maximum of 48 hours per year. If your employer provides more sick time than that, then they can provide more than 48 hours per year. But this is kind of what the statute says is the minimum, that it's 1 hour for every 30 hours worked, up to 48 per year. To be eligible to accrue the leave and use the leave, the employee must work at least 80 hours in a year for a Minnesota employer. And this leave is not available for federal employees, independent contractors, so folks who maybe would receive a 1099 instead of a W-2 for tax purposes, temporary farm workers, volunteer or paid on-call firefighter or ambulance workers, or for elected state officials. So that's the Minnesota Earned Sick and Safe Leave. Next, I'm going to talk about Minnesota Paid Family Leave Act. This is a newer law. There are some employers currently participating in this, but then it will roll out for everyone statewide on January 1st of 2026. Minnesota's Paid Family Leave Act provides up to 12 weeks of paid medical leave and up to 12 weeks of paid family leave for a maximum of 20 total weeks in 1 year. So if you're going to use both types of leave, you wouldn't be able to do a total of 24 weeks of paid leave. You'd do a total of 20 weeks of paid leave. The amount that you are paid on this leave depends on your usual weekly earnings. So it would be a percentage somewhere between 55% and 90% of your normal wages. For folks who have lower weekly wages, the percentage that they receive is higher. The higher the percentage, the higher the weekly wages, the lower the percentage that you receive on this paid leave. And you do have to provide notice to the employer to be able to take the leave. To be eligible for the Paid Family Leave Act leave, you have to work at least half-time in Minnesota. You have to have been employed at your workplace for at least 90 days. And you must have earned at least $3,700 in the last year from any job in the state of Minnesota. And you need at least 7 days of leave for a qualifying reason. And there are a number of qualifying reasons, but the one I'm highlighting here today, because we're talking about caregivers, is caring for a family member's serious health condition. And again, I have put family member in bold because that has a very broad definition under the statute for the Paid Family Leave Act as well. So similar to the sick and safe leave that I talked about just recently, a family member can include a spouse or domestic partner, a child or some stepchild, a child of a domestic partner or of your spouse, or a child to whom you have stood in the place of a parent. It can also include a parent or legal guardian of the employee. It can include your sibling, a grandchild, a grandparent, a son-in-law or daughter-in-law, or someone who has a personal relationship with you as the employee that creates an expectation and reliance that you will care for them without compensation, whether or not you live together. So again, that's just, if you have a close relationship such that you and the other person have this expectation that you would care for them without being paid for it, that can be a family member under the Minnesota Paid Family Leave Act, that you would be able to take the leave to care for as long as you qualify otherwise. And then lastly, I'm going to talk a little bit about the United States Family and Medical Leave Act, or FMLA. You may have heard that acronym before, FMLA. I think it's relatively well known. FMLA provides up to 12 weeks of unpaid family or medical leave. One thing that I think people don't always understand about FMLA is that it is relatively limited in who can take advantage of it. So to be eligible to take this unpaid leave, you have to work for a covered employer. You have to work at least 1,250 hours during the prior 12 months. And you have to work at a location that has 50 or more employees for your employer there, or work at a location where there are 50 or more employees within 75 miles for your employer there. And this is the one that I think really does trip people up. The law says that FMLA is available for individuals who have been employed at their workplace for at least 12 months before they go on the leave. Some employers have different policies, and they provide unpaid leave for people who haven't worked that amount of time. But what the law says is that you're not able, the minimum that the law requires is that you must have worked at your employer for at least 12 months before. And then in order to use the unpaid leave and have your job held for you by your employer under FMLA, you have to use that leave to care for a parent, child, or spouse with a serious health problem. So unlike the Minnesota Paid Family Leave Act and the Sick and Safe Leave that I talked about earlier, the US Family and Medical Leave Act definition for people that you can take care of is much more limited. So it has to be a parent, a child, or a spouse of the employee to be able to take that leave. Okay, next I'm going to talk about some legal solutions to the barrier of financial problems or financial barriers to caregiving. So as I said earlier, the AARP report found that approximately 22% of caregivers in Minnesota live in a household with income under $50,000. This can, of course, affect that person's ability to provide care because they need to continue earning at the same level to meet their needs. Or it can affect the ability of the person receiving care to pay for additional services as well. So there are a few different programs that I want to talk about in sort of briefly to try to gain some kind of additional financial assistance to pay for caregiving. So first, I'm going to talk about Medicare and medical assistance coverage for a few things, because I think sometimes those get forgotten. I'm also going to talk very briefly about the home and some of the home and community services that are available in the state of Minnesota, including the elderly waiver, the CADI waiver, alternative care, and the essential community supports program. Each of those is a complex program, and I could really spend an hour or two on each of them. So it's going to be pretty brief, but I wanted to just highlight that they exist so you can look into that more and explore that more. And then I'm also going to talk about the Community First Services and Supports program in Minnesota. This is also a relatively new program that was created to replace the former PCA and Community Support Grant program. So it provides a lot of the services that those programs provided earlier, but it's just kind of a different framework for it. So I wanted to talk about that as well. So to start briefly, Medicare or medical assistance coverage. One thing that I would recommend when there's a financial barrier, or even when there's not a financial barrier, is exploring whether there's coverage under Medicare or medical assistance for durable medical equipment or other types of more classically medical care that could increase the person's independence and or reduce their caregiving needs. So durable medical equipment could be something like a wheelchair, either a manual wheelchair or an electric wheelchair. There's really a whole host of different kinds of durable medical equipment. Typically, durable medical equipment does require pre-approval, so there is a process to apply for it, and that's something that you can work with your care coordinator. If you have a waiver, you would work with your waiver worker on that. And a denial of durable medical equipment coverage typically can be appealed either internally with your insurance company or through Medicare or medical assistance. One good resource I wanted to point out here is the Minnesota Office of the Ombudsman for Managed Care. They work with folks, they represent people and advocate for people with insurance companies. So they can give a lot of really great insight and information about how best to go about, trying to get pre-approval for durable medical equipment. Something else that can be covered under Medicare that I think not everyone knows is some amount of in-home care. So Medicare doesn't pay for long-term in-home care ongoing indefinitely, but Medicare can cover short-term in-home care, including things like skilled nursing visits when someone needs that on a short-term basis. So that's something to explore as well. If you have an Advantage plan or if you have a care coordinator for your Medicare, you can work with them on that. You can also contact CMS or you could contact the Medicare Rights Center for more information as well. And again, a denial of coverage can be appealed typically. Okay. So what if you know you're going to need long-term in-home care? Programs that are available to assist with paying for those are called home and community-based services, or HCBS. There are a variety of different programs in Minnesota. What I've highlighted here are ones that we usually see for clients that are in the population that we work with. So there are other programs as well that are worth looking into if you are caregiving for someone who is a younger individual. So first, I'm going to talk about elderly waiver briefly. Elderly waiver provides payment for services in the home to keep someone out of needing to be placed at something like a nursing home. It's available for folks who are age 65 or older who are financially eligible for medical assistance. Again, it provides for home and community-based supports. And to be eligible for the elderly waiver, you need to complete what's called a Min Choices assessment, which determines your level of need. And through that assessment, you need to demonstrate that you have what's called a nursing home level of care need. That doesn't mean that, your doctor is saying you have to go to a nursing home. It just means that once you've completed that assessment based on your answers, you fall within that category of the higher level of care need. The CADI waiver is similar to elderly waiver, but a little bit different. That is a program available to folks who are under the age of 65 when the waiver opens. And again, you need to be financially eligible for medical assistance to be able to qualify for the CADI waiver. It provides payment for home and community-based supports, again, just depending on what your assessed needs are. And again, through your Min Choices assessment, you need to demonstrate a nursing home level of care need. Another program that we sometimes have clients who are approved for is the Alternative Care Program. So this is a waiver program for people who are technically not a waiver program, but is a program for people who are age 65 or older who are not financially eligible for medical assistance generally, but who still have limited income or assets that would prevent them from being able to pay for their own care. There's a really specific calculation that I didn't want to go into here, but I just wanted to kind of highlight that even if you're not financially eligible for medical assistance, you may want to explore whether you're eligible for the Alternative Care Program to help offset some of those costs of the in-home care. And again, you need to demonstrate that you have a nursing home level of care need to be eligible for alternative care. And then finally, I wanted to talk about ECS, or Essential Community Supports. This is a program, again, available for folks age 65 or older who are not financially eligible for medical assistance, but who do have financial eligibility under the alternative care program. Essential Community Supports provides some in-home services, even when the person or when the individual does not have that nursing home level of care need. So if you go through the Min Choices assessment and you don't have that nursing home level of care need, then you could be eligible for essential community supports if you live in your own home and need one of the covered services to be able to stay in the community. I put a very small website here as well for a link to the Department of Human Services website that has a list of all the different types of programs that could be available to seniors to help pay for in-home care. So you can also look at that and explore that as well. And I'm going to talk later about some places that you can get in touch with to talk about it in more detail, what might be the best fit for you if you're going to look at trying to apply for one of these home and community-based service waivers. Okay. Next, I'm going to talk briefly about the Community First Services and Supports, or CFSS. So CFSS, as I say here, replaces the Community Support Grant and the PCA program, but it is very similar in that it is a way for someone to have a worker who comes into the home and does PCA style services for them paid through medical assistance. And there's also opportunity through CFSS to pay for not just the worker themselves, but also for services outside of the worker. There are a couple different models for CFSS that you can either be the person that's in charge of hiring and setting all those things up, or you can have a worker be in charge of those things. Again, I'm not going to go into all of those details. I think we do already have a presentation on our YouTube channel about the transition to CFSS, so I'd recommend checking that out. But just generally speaking, a Minnesota healthcare program enrollee, someone who is enrolled in a Minnesota healthcare program through the state or county, who is able to direct their own care. So that means that the person needs to be able to say what it is that they want for their care, and who has an assessed need for a service through CFSS is eligible to get the Community First services and supports. And one of the reasons that I wanted to talk about this here is that part of the transition to CFSS has been that there's a broader group of people that can be a CFSS worker who gets paid to provide caregiving to someone. So it can include a spouse of the recipient. It can include a parent of a minor child if the minor child is the recipient. And it can also include another recipient of CFSS services. So if you remember earlier in the slide deck, I mentioned that the AARP report found that approximately 12% of caregivers in Minnesota live with a disability themselves. Under kind of former rules, that person may not have been able to be a CFSS worker and get paid for their caregiving through the state for eligible participants. But now, under the CFSS program, even if you yourself have a disability and even if you receive services through the CFSS program, you may still be able to be a CFSS worker for someone else, just depending on your abilities and your skills and that person's needs. So in order to be a CFSS worker, you do need to be certified to provide CFSS services, which means you need to go through a training and pass a test. I'm going to talk a little bit later about that training as well. Okay. Next, I'm going to talk through legal solutions to the barrier of not being able to access the person that you're trying to provide care for when that person wants you to have access to them. So again, just to be clear, when we provide services to the person who would be receiving the care, not specifically to the caregiver. And so what I'm talking about here are situations where the person who receives the care wants the caregiver to have access to them. I'm not going to be talking about ways to overcome the person who would be receiving the care wanted to cut off contact. So that's a different situation. But when the caregiver and the person who would be receiving the care, both want there to be that access, there are some ways to either ensure that access can happen, except for some very rare exceptions, or to request that that access be allowed if there's some external barrier. So I'm going to talk in brief about planning ahead by doing either a power of attorney or a healthcare directive or both. I'm going to talk about some reasonable accommodations opportunities for this barrier. I'm going to talk a little bit about some new limitations on visitor restrictions for persons who are subject to a guardianship or conservatorship. And I'm going to talk a little bit about designated representatives or designated support people for folks who are living in an assisted living facility in Minnesota. Okay, so first, lawyers are typically, depends on the person, risk-averse people. And one thing that I think is really important is trying to plan ahead. So doing something like a power of attorney and a healthcare directive can really ensure that the people that you want to give care to you in the future do have access to you and are able to do that work that you want them to do for you. So a healthcare directive is a written document that can be used to appoint a healthcare agent or to provide instructions for your care. It can do both or either. Unless you limit it in your written healthcare directive document, the automatic powers for a healthcare agent in the state of Minnesota include deciding your healthcare treatments, including life-saving or life-preserving treatments, choosing your providers and where they are, choosing locations for your care, including whether you'd be at a nursing home or at home. And it includes full rights to your medical records. So the same kinds of rights that you would have to your medical records are automatically a power that a healthcare agent receives if you have appointed them. And importantly for this particular presentation, one of the automatic rights of a healthcare agent, or one of the automatic powers of a healthcare agent who's appointed in a healthcare directive in Minnesota, is to visit the person who has appointed them at a healthcare facility. There are some limitations where a facility can block that person's access if there's sort of a danger involved, but otherwise, unless it's limited by the healthcare directive document, that person should be able to visit you at the healthcare facility. And then the power of attorney is a financial document. So that's appointing a person who's called an attorney, in fact, to manage your finances. And again, you really get to decide within that written document what kinds of powers and authority you want that person to have. But it can include things like access to your bank accounts, if you want them to be able to get into your bank account for some reason, and other types of financial transactions. One important thing about a power of attorney in Minnesota is that if you want it to be effective, if you've lost capacity, you need to specifically say that in the document. In the state of Minnesota, a power of attorney would typically lose effectiveness and not work anymore if you've lost your capacity. So you do need to say specifically in there that you want it to be effective, even if you've lost capacity. A healthcare directive, kind of the opposite of that, a healthcare directive doesn't become effective unless you've lost capacity, unless you say differently in the document. Okay. Next, I'm going to talk about reasonable accommodations, and I apologize, I know the type is a little bit small on this slide deck. But one thing that we see sometimes is that there may be a barrier to being able to access the person because there's some kind of rule or decision that's been made by the housing provider, the landlord, related to the caregiver being able to come into the building. So the United States Fair Housing Act and the Minnesota Human Rights Act prohibit disability discrimination. And disability discrimination includes refusing to make a reasonable accommodation for someone to accommodate their disability. Reasonable accommodations can be things like changes to rules, policies, or practices when that change is necessary for a person with a disability to have equal opportunity to use and enjoy their home where they're living. So some examples would be if you are living in an apartment and you need a live-in caregiver, that you can request to have that person be allowed to live with you as a caregiver through a reasonable accommodation request. You can also request an accommodation for a larger unit to be made available to you for a live-in caregiver, or for durable medical equipment if that takes up a lot of space in your apartment. And you can request a reasonable accommodation for your live-in caregiver's income not to be counted for income-based housing. So normally income-based housing would include the income of everyone who's living in the household. But if you have the need for a live-in caregiver, you can make a reasonable accommodation request for that caregiver's income not to be counted, because they are there for caregiving purposes only. Some tips about making a reasonable accommodation request is the law says that the request does not need to be made in writing. It does not have to come in a particular way, but it is a good idea to submit a request in writing to your landlord when you're requesting a reasonable accommodation for a disability. And the best idea is to keep a copy for yourself too, so you have a record of what you requested specifically. The requested accommodation has to be necessary because of your disability. So it has to be related to your disability and reasonable to accommodate that disability. And a housing provider is allowed to refuse unreasonable requests, but they do have to engage with you and to try to come to what would be a reasonable request. So they're not allowed just to ignore your request. That could be disability discrimination if you make a request for reasonable accommodations and they just ignore you. So this can be something that can be really helpful if you're having trouble, if your landlord is saying, oh, your child has been here a lot of days and we only allow guests for a certain amount of time. If that child is there because they are helping you with things related to your disabilities, you may be able to make a reasonable accommodation request to allow them to be in the building, perhaps more than what the usual rule says, in order for you to be able to enjoy that your home to the same degree as somebody else who doesn't have a disability. Okay, next I'm going to talk about guardianship visitor restrictions. This is something that has been changed in the law this year. I put the statute here. It's Minnesota Statutes 524.5-120. And this is in the Bill of Rights for persons who are subject to a guardianship or conservatorship. So under this new law, the person subject to a guardianship does retain the right to visitors. That's not really a change. And other communications and interactions with visitors or with persons of their choosing, unless the guardian has good cause, which means, very good reason to believe that a restriction on visitors or communications or interactions is necessary due to a substantial risk of significant harm to the person who's subject to a guardianship or conservatorship. The guardian is required under the law to first seek limited restrictions whenever possible. So that could be things like supervised visits, video calls, letters instead of in person, something like that. So the guardian is first required under the law to explore those other options rather than just stopping contact altogether. And under this law, the way that it's been changed, the guardian has to give written notice to the court who is in charge of the guardianship, also to the person subject to a guardianship, and to the person that they want to restrict access for within 48 hours of making that restriction. And the notice to all those individuals has to include instructions on how to seek modification of the restrictions. So persons who are subject to a guardianship have always had the right in Minnesota to ask the court to make a change to a restriction like this that their guardian has imposed. But now the law kind of puts more on the guardian to make sure that they're notifying the person subject to the guardianship that they're making this restriction and giving specific instructions to the person subject to the guardianship on how they can request to have that modified if they want the person to still be able to interact with them. So that's an important change to know about. Okay, and then lastly, regarding this barrier about access to the person, I'm going to talk about designated representatives and designated support persons for folks who are living in assisted living facilities. In an assisted living facility, the law says in Minnesota that the resident can identify what's called a designated representative who receives notices from the facility in addition to the resident, and that the residents do have the right for their designated representative to participate in care and service planning. So kind of like what I mentioned earlier about how our office works, a designated representative is someone that the resident has chosen and someone that the resident wants to participate in their care and planning. So a designated representative would not be able to override a resident's decision, but they can certainly participate in the way that the resident wants them to. And the assisted living is not the one who decides who the designated representative is or what that person will be included in. It's the resident who gets to decide who the designated representative is with some limitations and what they get to participate in, again, with some limitations. In addition, residents can have what's called a designated support person present whenever the resident chooses, subject with some limitations here for if the person is acting violent or threatening or to ensure the support person is not living at the facility. So again, this is something where the resident gets to decide who the designated support person is and when they get to be present, subject to some of these limitations. And then importantly, the statute about the assisted living resident bill of rights does say specifically that the assisted living facility can't retaliate against the resident for complaints or grievances that are raised by someone either on their behalf or by the resident themselves. So if the designated representative or designated support person is making complaints about the care needs or the level of care that they're receiving, the facility is not permitted under the law to retaliate against the resident for those complaints, just like the facility would not be allowed to retaliate against the resident for the resident making complaints or grievances. Okay. So last, I'm going to talk about legal solutions to the barrier of having little or no guidance. So that could be either little or no guidance from the person receiving the care or just not having enough access to the training and information that the caregiver needs to provide the best care that they can. As I mentioned earlier, the AARP report said for Minnesota in 2025 that only about 12% of family caregivers reported receiving training for assisting people with their activities of daily living, instrumental activities of daily living, or behavioral management. So that's a pretty low number. And there are some things that the caregivers can do, some legal solutions and kind of practical solutions that caregivers can access to be able to have more information and training. So first, again, is plan ahead with the power of attorney or healthcare directive. It's so important that I did put 2 slides in here too. So you might recall from when I earlier talked about this, a healthcare directive can be used to appoint a healthcare agent, and it can also provide instructions for your care. The Minnesota standard form that you can use, which you can access on Law Help MN's website, has questions about what are your beliefs for how you want end-of-life care to be done? What do you believe is more important between managing pain and having functionality? All these different questions that you can think through. And whatever you write down on that document for the healthcare directive really assists your healthcare agent in determining what it is that you want them to do on your behalf and what kind of care you want them to be arranging for if you don't have the capacity to tell them anymore. So that can be really helpful to any caregiver working with you in the future to just write it down now when you're doing the document. Make sure that you're including there what it is that you want them to be thinking about and factoring it in, and what your priorities are and wishes are. That can be really, really helpful. One way to kind of think about it is that the healthcare directive can be the care map for your caregivers to follow. You can't give them illegal instructions in that care map, but anything that's legal that you put in those instructions is something that your caregiver can use to help provide care in the way that you want them to. It also provides instructions for your providers too. So your providers can look at the healthcare directive as well and confirm that what is being asked of them is, in line with what you wanted, so that the healthcare agent and the providers can also be on the same page. So again, the healthcare directive is a really important planning tool and care map that you can provide to your caregivers for whenever you're not able to give them instructions. Another thing I wanted to highlight, this is not technically a legal solution, but if you're looking into becoming certified for to provide CFSS services, to be a CFSS worker, there is a free online training through the Department of Health or Department of Human Services website. And you can also go through that training even if you're not looking to be certified formally for CFSS work. There's no fee to do the training. It is computer and also mobile device compatible, so you can do it on your smartphone if that's more accessible to you. And the training is available in English, Hmong, Somali, Spanish, and Russian right now. I don't know if they're planning on expanding that, but those are the languages it's available in now. I included on this slide a screenshot of the information that this training provides. So there's an overview, there's a discussion about person-centeredness, how to be focused on what the person receiving the care needs and what their wishes are. Things about positive supports for challenging behaviors. So, one of the things that we talked about earlier is the limited training and behavioral management for caregivers, and positive supports for challenging behaviors is something that can address some of those behaviors and how to manage those behaviors best while maintaining person-centeredness too. There are some things that are more specific to, CFSS certified workers, like mandated reporting and professional boundaries and data privacy, but you can certainly review those too, even if you're not planning on being certified. And then helpful information about preparing for an emergency, having a plan for an emergency, infection control, and some standard precautions to help as well. Body mechanics, how kind of best to help somebody physically move their body. And again, things that are more related to CFSS workers that are going to be certified. So time cards and documentations. If you're an unpaid caregiver, that's not something that you would necessarily be needing to review. But again, this is a free training. You are able to access this training at any time online. There are also some other advocacy agencies and other agencies in Minnesota that provide additional information and some training and support groups for caregivers. So I put the AARP Family Caregiver Resources list first here, the link to that. If you look at that link, there are a lot of different other organizations that are listed there that have caregiver resources, training programs, and support groups and things like that, either for a fee or sliding scale or no fee at all, just depending. Another good place to look is at your local area agency on aging. I put the link here for the Minnesota State Board on Aging, which will get you to the link for your particular region, for your area agency. The area agencies on aging that we work with in our region, all three of them have resources dedicated for caregivers. So those are great places to reach out to as well to have some resources about caregiving. Minnesota Aging Pathways, which was formerly called Senior Linkage Line, is also a great resource to contact for caregiver resources. They do amazing work in helping people figure out what their insurance policies can help them with and what other options they have for coverage and insurance. So when you're looking at, those durable medical equipment, you can also reach out to Minnesota Aging Pathways for some information. And they can help with open enrollment for Medicare as well, helping you decide what you want to do. And they have resources that are specific to caregivers as well. I also put the Minnesota Association of County Veteran Services offices. The county VSOs can be really helpful in connecting veterans with services as well, and their caregivers connecting them with services. So that's a wonderful place to reach out to. And then finally, I put here the Medicare Rights Center National Helpline. The Medicare Rights Center is a national organization that works in the area of Medicare and advocacy related to Medicare, but they also operate a helpline that can help you kind of determine what's going on with your Medicare, what are your options for your Medicare, and how best to move forward. So these are just some of the resources that are available to you, and I really recommend going through each of them so that you can get some additional resources with caregiving. Right, and then that is the end of the presentation today. Thank you so much for sticking with me till the end. The client intake number again, if you want to open an intake for Smurls or anywhere else